Thank you.
Good morning, Your Honor.
This case management conference is in the matter of case number CFI 030-2023 and is being held by way of video conference before His Excellency Justice Nasser and Nasser. The claimant is represented by Al-Haji Al-Nubi, advocates and legal consultant, and the lead counsel is Ms. Asha Bijoy. The defendant is Snyder Prime Limited and is represented by Mr. Shakti.
Yes, good morning, Your Honor.
Will the judge and the parties please confirm that the situation is as I have stated?
I confirm.
I confirm as well.
Thank you all.
Welcome both parties. We'll start with the claimant and then we'll come back to the defendant.
Much obliged, Your Honor. Your Honor, I am the representing counsel for the claimants. We have three claimants in this case. The claimant number one is an entity by the name Sam Precious Metal FZ-LLC, which is a company registered in the Dubai Development Authority. The claimant number two, Mr. Sami Riyad Mahmood Abu Ahmad, is the 50% shareholder of claimant number one, Sam Precious Metal. Claimant number three, Rosie Sun, is a 25% shareholder in claimant number one, Sam Precious Metal. The defendant number one is an entity again by the name Snyder Prime Limited. They are incorporated in ADGM. And defendant number one is a 25% shareholder in claimant number one. Defendant number two is the current sole shareholder of defendant number one. And defendant number three, Mr. Shakti Chauhan, is the former and the present director of defendant number one. Your Honor, this case involves a lot of factual complexities. However, for the purposes of the current CMC, we do appreciate that we don't have to go into the merits of the claim. I would just be highlighting what the claim has been put forward for. The claim is a compensation claim and a damages claim filed by the claimant numbers 1 to 3 on the ground that there has been various breaches and violations of documents that has been entered into between the parties, including the Memorandum of Understanding dated MOU, which is a document, the Memorandum of Association, and then the Share Transfer Agreement, a subsequent addendum to the Share Transfer Agreement, and various shareholder resolutions and the General Assembly decisions. It is a claimant's position that the defendant number one has violated various provisions of these documents and has also transferred or assigned the defendant number one shares to a third party without taking confirmation or approval from the board of directors or the managers, the partners of claimant number one. The defendant, it is a claimant's position that the defendant has failed to disclose their identity on the true shareholder ownership of the defendant number one. Also, that the defendant has made repeated attempts to defame claimant number one by circulating information that are defamatory. Now, when I look into the heads of claim, we have basically three heads of claim. The total amount claimed is US dollars 15.6 million odd amount, which is calculated as, at the moment, as per the current pleading. The major head of the loss is because of the financial loss suffered by the claimant number one because of the various breaches and non-compliances amounting to 14.2 odd million amount. Then and another head of about $407 million because of non-compliance in terms of agreeing to the closure down of a subsidiary entity in the Sharjah Free Zone, which is quantified at the moment as $407. And the third head of compensation claim is a 1 million claim caused due to the reputational loss suffered by claimant number one because of the various breaches and defamatory statements made by the defendant number one and defendant number two and defendant number one through defendant number 3 and 2. Now, it is the defendant's position that they have complied with all the MOU, the STA. The prior made by the defendant, which is quite interesting and which can be found on bundle paragraph number, page number 63. The defendant is, as prayer number A, seeking a dismissal of the claim. As paragraph number B, the defendant is inviting the court's attention to another proceeding pending before this court, which is CFI 019-2023, which is a derivative application for filing a derivative claim. And as point number C, on page number 63 of the bundle, the defendant is also praying to this honorable court. In the alternative, the records of CFI 019-2023 may be called for. So the second prayer is the current proceedings be stayed until the final judgment is passed in CFI 019, which is a derivative claim. And as prayer number C, they are seeking, in the alternative, the records of CFI 019-2023 may be called for and an external auditor be appointed, preferably from a Big Four auditing firm. Your Honor, the submission is that we have a compensation claim, which is totally unrelated to the derivative claim, which is listed as CFI 019-2023. And prayer number B and C, sought by the defendant, is therefore not maintainable because these are two different proceedings. And there is no way the court can award a relief of staying the current proceedings on the basis that there is another proceeding which is totally unrelated to the current compensation claim, and also call for records or for an auditor appointment. Now, when it comes to the defendant's defense, they don't have a counterclaim. They simply take the stand. They have complied with everything, and they don't owe this $15 million to the claimants. Now, coming to the case management bundle, we have had discussions with the defendants on the various aspects of the case. And there has been, as we speak, disagreement on the issues to be framed in the current proceeding. I believe, may I, with your permission, take you through the disagreements on the issues?
Yes, please.
So currently, we have in the bundle page number 109, which is a case memorandum, paragraph number 3, the list of issues. We have also on page number 113, list of issues raised by the defendant, not agreed by the parties. Now, there has been exchange of communications between the parties on the list of issues. Apparently, this morning, Mr. Chauhan has sent an email to the registry raising objections to the fact that there is no list of agreed issues in the case. If I may take your honor through the communication, the last communication the parties had, as a claimant's Part 1 counsels has reached out to Mr. Chauhan seeking his concurrence on the list of issues. He then replied back by saying that on th of July, I quote, yes, we have requested for a call with Mr. Chauhan to discuss and agree on the list of issues. He then replied by saying, yes, we can have a call. We agree to your issues subject to addition of our issues. Your Honor, the wording is very clear. It is very clear that they do not raise an objection to our list of issues. The only thing that Mr. Chauhan was highlighting is we are agreeable to your issue, provided you can include our issues also. So there is no objection raised to any of our issues. The only thing that they want is to add their list of issues. Now, Your Honor, if you look at the list of issues.
Correct. Should I wait for my turn? Apologies. Please go ahead.
Thank you.
Can you not interrupt, please? I'll give you the chance to respond.
Thank you, Your Honor. Apologies.
Thank you.
Your Honor, defendant has come up with a total of 10 issues. And whereas we have a list of 5 issues, which Your Honor will find on page number 109 and 110 of the case memorandum. Now, what is very evident from the respondent's email is that they are agreeable to our issue. All they want is their list of issues to be added. So we have done this exercise of comparing our issue versus their issue. We can also, during this discussion, Your Honor, I can take Your Honor through the list of issues on a comparison. And it is very clear that issue number 1 to 5 raised by the defendant is in fact reflected in a different manner in our issue number 1 to 4. To give you an example, Your Honor, our issue number 1 reads, whether the defendants have breached, which is on page number 109, this reads, whether the defendants have breached the agreed terms and conditions of the Memorandum of Understanding dated 24th of March 2018 and share transfer agreement dated 5th February by not providing the working capital requirements. That's the main issue, and followed by 3 sub-issues, which reads whether the defendant's non-compliance and failure in meeting the work capital commitment has caused financial loss to the claimant, which is our main case, whether the claimant number 1 has sustained loss of profit due to the shortfall of the 100 kg of gold. Again, very much what we have pleaded. What is the effect of signing the shareholder resolution dated 31st December 2020, and what are the obligations of the parties therefrom? This is our issue number 1. Now, if I may take Your Honor to the issue raised by the defendant as item number 1, which it reads, whether the defendants have complied with the agreed terms and conditions of the Memorandum of Understanding dated 27th March 2018 and the share transfer agreement dated 25th February 2020 by providing as on 31st of December USD 8.2 million in working capital, which is essentially what we are also addressing in issue number 1. Therefore, it is my humble submission before Your Honor that I have done comparison of our issue number 1 to 4 with their issue number 1 to 5. And it is just a duplication and the wording difference. Otherwise, what we are trying to achieve by identifying these issues, and as per the overriding objective of the RDC, the issue number 1 to 5 or 1 to 4 in our issues would very much address the defendant's issue number 1 to 5. Therefore, if we come back to the additional issues that are raised by the defendant, which is from 6 to 10, the defendant want this court to look into aspects such as, if I may read issue number 6, it reads, whether the claimants have wrongfully issued a false dividend voucher to the defendants for an amount of USD 2.7 million. Now, in our compensation claim, do we really have to look into this issue of the dividend voucher? Because that's not what we are investigating in this current case. We are investigating whether the claimant has suffered a loss of 15 million because of non-compliance by the defendant. Now, defendant want to bring in an issue which is not related to the claimant's case and direct the whole proceeding in a direction that is not required. And that would not be efficient utilization of the time and cost. It is the same with issue number 6 to 10. All of these issues are dealing with violations or breaches, which should not be a point of investigation for the court to come to the conclusion on whether or not the claimants are entitled to the compensation. And because of this, we were not agreeable to include the 6 to 10 in the list of issues, whereas our list number 1 to 4, which essentially covers pretty much the claimant's issue number 1 to 5, is already been accepted. And we have an agreed list of issues, or rather, there is no disagreement, at least from the email of Mr. Chauhan. So it is my humble submission before Your Honor that also, Your Honor, the provisions are very clear. If I may read out to Your Honor, RDC paragraph number 26.9, subclause number 3, the RDC says, an agreed list of important issues in the case. The emphasis to be added on the word important issues, Your Honor. And there are precedents also. If I may, with your kind permission, Your Honor, refer to a DIFC case, which is DIFC 075 of 2020, Johnson Arabia LLC versus BIC Contracting. The court has clearly highlighted this RDC 26.93 and has made it very clear that the list of issues then constituting the roadmap by which The judge is to navigate his or her way to the just determination of the case. Now, the question is, what is the case? The case is whether or not the claimants are entitled to the 15 million odd amount compensation or damages. Now, in order to come to that conclusion, what is the roadmap that we have to set? Do we have to investigate about the violations of the claimant? It is not, because to arrive at whether or not the defendant has highlighted the breaches are not relevant or material in coming to a conclusion on the claimant's case. Also, Your Honor, if we look at the prayer made by the defendant, the prayer wants, the defendant is directing us to a different proceeding, which is a derivative claim 019. And the reliefs sought in that 019 is exactly the same, which they would also want to cover under the current case issues. Therefore, since there is already a parallel proceeding, which will anyways look into this aspects, which is currently covered under 6 to 10 of the defendant's issues, it is my humble submission that this current proceeding should be proceeded on the basis of the first 5 agreed list of issues, which were produced before Your Honor in the case memorandum. Apart from the list of issues, Your Honor, there are not much of disagreement. We have a disagreement on the appointment of the expert. We as a claimants would want to appoint our own expert, whereas from the case memorandum, I understand the defendant would want to appoint a court-appointed expert. That is another area of disagreement that the parties have. Also, we anticipate that there will be disclosure applications in the proceeding because there has been requests for some documents which has not been forthcoming from the defendant, and similarly from we anticipate similar disclosure against us by the defendant. So this is one other application that we anticipate. Last but not least, Your Honor, we would also be requesting Your Honor's kind permission to modify the pleadings, as we have come to see that the pleadings would require to be modified to make the claimant's case more clear. So we would be making an application to modify the pleadings to, as per the RDC provisions, to make it very clear on what the claimants are claiming and what the reliefs they are pleading. This has occurred because we have recently got an expert appointed, a third-party neutral expert appointed, and a lot of things have come into our light, which requires us to modify the pleadings. That's all, Your Honor. Thank you.
This is an application which you should file, during the course.
Yes, Your Honor. Yes, we will be making an application to modify the pleadings, the statement of case.
Okay. In relation to the expert, the court does not appoint an expert. The DFC court does not appoint an expert. It is on the parties to agree on an expert, or each party may get his own expert.
Much, Your Honor.
Now, in relation to the list of issues, let's listen to the defendant's representative. Mr. Chauhan.
Thank you, Your Honor. Your Honor, I would like to bring your attention to the two facts briefly discussed by claimant's counsel. We actually, we are defendants in this case, but we had filed two Part 7 claims early on. The first one was CFI 006, an interim injunction, in which we received an order subject to the evidence that we had presented on 27th of January. The same order was confirmed again on 17th of July, right? So the court was satisfied with the evidence that we had presented. And the second Part 8 claim that claimant's counsel is referring to is CFI 019. That's the petition to bring forward a derivative action, and the pleadings, as the claimant's counsel correctly said, are exactly the same. So therefore, the issues that we have highlighted, are required to respond to their concerns. And just to repeat again, we have already received an order which was given based upon the evidence that we had earlier presented. So pleadings in this case, CFI 030, the current case, are exactly similar to the pleadings in the CFI 006 and CFI 019, the interim injunction claim and the petition to file a derivative claim. The only difference is that here we are the claim, that we are the defendants and they are the claimants. The same issues are being discussed, and under that context, all 10 issues that we have raised, which we have incorporated in the registry, are relevant, right? That's our contention. Additionally, on 17th of July, I had sent an email to the claimant's representative, saying that we agree to your issues subject to addition of our issues. And in that, I was clear that our issues are relevant and will be used to answer any of the questions they have. Additionally, I spoke with him, the representative, yesterday, and I confirmed the same over a phone call. And finally, this morning, I sent an email again just to ensure that the same thing has been confirmed. So our point of view is, in the interim injunction, same things have been discussed. They are same pleadings, and our issues should be incorporated so that we can successfully answer to their concerns. Also, Your Honor, I would like to add that CFI 030, which is the current case, is an afterthought by the claimant, and it was filed after we received the interim injunction order, and subsequently when we filed after we filed the application for the derivative claim. And the reason why we filed for Part 8 claim, Your Honor, is because we have not received the audit statements from the claimant for the last 2 years. Therefore, we cannot come up with the quantum of our claim amount, and that's our primary challenge. So, and also just to bring to Your Honor's attention, I'm not able to access the case bundle. So, and we thought that our objective is to finalize the list of issues. So, that's where we're at, Your Honor.
So now, in page number 112 of the bundle, which reads the list of issues. So there are important agreed issues in this case are as follows. So those issues are agreed, I believe.
No, Your Honor. So what I'm trying to say, Your Honor, is we have not agreed on the list, and I communicated the same over an email, over a phone call, and again over an email this morning. And the claimant's counsel, they left out our issues. And also, Your Honor, I don't have access to the case bundle. And what I'm trying to emphasize, Your Honor, is that we received an interim injunction order on 27th of January, which was subsequently confirmed again on 17th of July, based upon exactly the same pleadings, which again the claimant and we have in this case. So if we could add both the issues, theirs and ours, that would be very helpful.
Your Honor, if I may please make my submissions. Your Honor, I would again go back to the initial submissions that I have made, that the issues that the defendants would want to include in the current proceedings are not relevant to the current claim. Plus, there is a proceeding that is pending before this court, which is looking into those issues exclusively, because those issues are falling within the purview of the derivative application. And that's currently pending before this honorable court as CFI number 019. And the only difference is the derivative claim is brought in by the defendants as a claimant, wherein we are the defendants in that proceeding. So the relief sought in these two claims are entirely different, Your Honor. The current claim that is filed by the claimant, Sam Precious Metal, and two others, is for a damages and a compensation claim. And what the defendant is trying to do is to include issues that are being relevant in the derivative claim into a compensation claim. The problem is, if we try to investigate those aspects in a compensation claim, we would not be doing justice to the compensation claim, because the compensation claim objective is only to find out whether or not the claimant are entitled to the compensation, whether or not the defendants have failed or breached, and whether because of their failure or breach, did the claimant suffer any damages. And that should not be a proceeding in which we further investigate whether the claimants have breached, which is anyways under the consideration of the court who's hearing the derivative application. So, Your Honor, we will have, if we try to include those issues in the current proceedings, we will have multiple proceedings addressing the same issues. And we would not be doing justice to both proceedings. So it is my humble submission, Your Honor, that for clarity and for and to be in compliance with the overriding objective of the RTC, we have to stick to the claimant's case. And this is the claimant's case that they have suffered loss. So the only point to be looked upon by this court in this application is whether or not the claimant has suffered the loss. That should not be a fishing expedition for the defendant to get documents from us, which so that they can strengthen their derivative claim. My lord, that is the objective here. So it is my humble submission that we should stick to the claimant's main case and identify the issues that are relevant and important and material to the finding. Thank you, Ron.
Mr. Chauhan, there is in the same page 1.1 in section
Your Honor,
D. First of all, the bundle, you said you don't have access to the bundle. The bundle is available on CMS.
I have access to, I can access the list of their issues and my issues. I have that document open, Your Honor, but the case bundle, I'm unable to access.
No, but the case bundle is available on CMS.
Yes, Your Honor, if I may please interfere.
In the court portal, it's available. It's accessible.
If I click on case bundle, Your Honor, I see draft submitted and hearing completed, right? I'm unable to see anything over there. If you can, where should I be looking at, Your Honor?
When you go to case CFI 030-2023, you see case bundles, then case management conference 20 July 2023. This is the bundle which you can access. View bundle, and then it takes you to a page where there is a bundle.
Your Honor, I see no records find. So let me just open it again. When I go to the page, the first case event is case management conference, 20th July 2023. Under forms, over the document page, I see a small number 0. I still proceed. So this is the one, correct? Case management conference.
Yeah,
sir, I see a document and the number is 0 on top of that. But when I still click, I see join video conference. I see on the left side, it says documents and it says no records found. I can send a snapshot of this to the registry.
Your Excellency, if I may, I think Ms. Asha has to share the bundle with Mr. Shakti. Have you done that, Ms. Asha?
Your Honor, the limitation is I am the Part 2 counsel, and the Part 1 lawyers had exchange of communication, is what I was told, with Mr. Shakti, and access was also given. The difficulty is that Mr. Shakti is not a lawyer, and I'm not very sure whether they are familiar with how to access the bundle. Although there are 2-3 proceedings that are currently pending, it looks to me that the request is coming at the very last minute. Although we had discussions about the submission of the bundle, Mr. Shakti was aware that a bundle has to be submitted, and his cooperation is also very much important. I think it looks to me that the request and the complaint is coming at the very last minute. If he had any concerns, he should have raised. I mean, of course, Mr. Shakti has raised a concern on the agreed list of issues. Yes. But why was the issue of not able to access the bundle not brought to the court's attention till now?
Your Honor, my understanding was that the dates and the list of issues was the point of discussion today, and that was my understanding.
Anyways, you have the list of issues, yeah?
Yes, sir. Yes, Your Honor.
Okay. So tell me, how are the issues, the list of additional issues raised by the defendant?
Yes, Your Honor. So
how
Your
are
Honor,
they related to this claim?
So you're asking like how are our issues, us, the defendant, related to this claim, right?
Those issues starting from whether the claimants have wrongfully issued a false dividend voucher to the defendants for an amount of 2.7 million. Then the second is whether the claimant has wrongfully, in contravention of all accounting principles, categorized loan as equity for the purpose of showing the net worth of excess 15 million to meet the regulatory requirement of UAE good delivery and going
Yes, Your
on
Honor.
until the last issue, which is whether the claimant number one is authorized to do speculative trading activities in contravention of the license activities. So how
Yes,
are
Your Honor.
those issues related to a compensation claim?
Your Honor, so the dividend voucher one, if you allow me to explain this one, the claimant's claim is for money, and their claim is for an amount that they have set. But if they factor in the dividend voucher, which they claim, the dividends which they claim that they have paid to the 25% shareholder, which is the defendant, and the money was never received by the defendant, then their claim amount would be offset or would not be there. Additionally, the contraventions that we have highlighted goes to the heart of the shareholder reserve matters that was highlighted in the MOU, which is the primary constitutional document of the company, and the share transfer agreement. So, the points we are highlighting are the violations of share transfer agreement and MOU's shareholders reserve matter, and these are the concerns which demonstrate that they have violated a number of reserve matters, right? And so that's the point. Additionally, when us, the defendants, we say that we have not had access to audit reports that shows that for the last 2 years, things have been hidden from us. So how can claimant make a claim without giving us any idea of the books and records of the company for 2 years? So most of the violations here, Your Honor, are the shareholder reserve matters, which are part of the MOU and share transfer agreement, which we will be using, and the claimant would be using, but they have all been breached.
Your Honor, if I may please step in. This is exactly what is covered under the agreed list of issues number 1, Your Honor. The issue number 1 is analyzing whether or not the parties have breached the MOU and the share transfer agreement, and the shareholder reserve matters is part of the share transfer agreement. So, which is already there, which is very broad enough to cover all of these aspects.
So highlighting the issues which were breached, basically it nullifies the share transfer agreement. And sorry.
Yeah, so sorry. So in fact, that is our case also, and we have already identified an issue. Now, why do we have to investigate on breaches where we have a broad issue that would cover whether or not the parties have complied with the terms of the MOU and the STA?
Your Honor,
in fact, rather, Your Honor, if I may please add on, if we look into these minor sub-issues, which the defendant have always had an opportunity to address if they wish to, then the attention of the compensation claim would focus on a breaches claim by the defendant. Here we are the claimants, Your Honor. We have paid the court fee and we have a case before Your Honor court, and we have identified the issues which would help us to identify whether or not the claimant has suffered loss because of the breaches by the defendant. Now, what the defendant is saying is, defendant wants to investigate on us to see whether we have breached. They don't have a claim that they have suffered a loss. Their only case is that we have violated the breaches. Now, if they have a case, ideally they should be filing a case by paying the court fee and by producing a Part 7 claim. Till now, we don't have a Part 7 claim. All we have is a Part 8 claim. And there is a parallel proceeding in which the exact same issues are going to be addressed by the court. So, Your Honor, it is very, very simple and clear that the defendant want to thwart the entire legal proceeding by directing the court to focus on issues that are not relevant and material to the claimant's case. And this would be a worthless exercise, Your Honor, and this would take a lot of attention from the court and would lead to unnecessary evidence, unnecessary wastage of time and cost, because we will be investigating on something which would not help the court to come to a conclusion on whether or not the claimant has suffered the loss.
It is not a parallel proceeding, Your Honor. The interim injunction order has been passed, and we've already had hearing for the petition for writ of claim, and we are awaiting, an order from, in that case. And here, if the claimant says, since it's a money claim, right, the $2.7 million of dividends which the claimants have, they've issued dividend vouchers used in their audit report, but they have never paid to the defendant. That goes to the heart of the amount of the quantum that they're setting. That is, so if they have a number, that is clearly off by 2.7. That is, that is a reason why this point should precisely be there. Our issues will prove that their case is, is totally wrong, and they want to change the pleadings, so issues should also change accordingly, Your Honor.
Okay, this point, okay, and the other points, how are they related?
How are they related? Okay. So which point would Your Honor would
Your
like
Honor,
to focus
point
on?
number 2 talks about accounting principles violations. How is it connected to the claimant's claim for compensation? It is not the defendant's case that the claimant is not entitled to the compensation because they have violated the accounting principles. So then why do we have to investigate on that?
This is,
Your Honor, if we... Which point are we referring to? I'd be happy to expand upon that.
The point is whether the claimant has wrongfully, in contravention of all accounting principles, categorized loan as equity for the purpose of showing the net worth in excess of 50 million to meet the regulatory requirement of UAE good delivery, an accreditation laid by Emirates Bullion Market Committee.
Yes, Your Honor. The intention here is, once we can establish and demonstrate to you with an expert report, which we have from Deloitte, that a loan was highlighted as equity, that shows that the audit reports prepared by the claimant are fudged. So any numbers that they come up with, based upon the audit reports and the books and records, that first of all they have withheld from us. And this audit report we were only able to get from another case filed by the claimant in Dubai courts. That is how we got that audit report. So, Your Honor, this shows the audit report that they are concealing from the defendant and are filing with other regulatory authorities have been cooked, and therefore shows that the numbers that they would be presenting are off.
Your Honor, it is my humble submission that this would not in any way aid the court in deciding whether or not the claimant has suffered the loss, because we are investigating on a totally new issue, which is not the subject matter for the current claim. And the point is about the accounting records. These accounting records would anyways be a part of the proceeding. We don't have to look into these aspects in a compensation claim. In fact, the strategy here is to divert the court and to deviate from the main case.
Your Honor, why my humble submission is, why would the court pass an injunction order if our issues were not relevant? And where is the question of compensation when the numbers come put forth by the claimant would theoretically be based upon audit reports which we are which we have the proof that they have cooked. So looking at the relevance and the order that was passed in between the claimants and defendants in other proceedings which are not parallel, Your Honor, that proceeding has ended. That is where I would like to bring your attention to.
Honor, the proceeding is not ended. We are expecting an outcome on 019, which is the defendant's application for bringing in a derivative claim. And in that case, Your Honor, all of these issues have been highlighted. In fact, we have a very bulky bundle in which exact copy of the same allegations are there under the derivative claim. So we are running a risk of proceedings, if that application is allowed, of the same court looking into two different cases, same issue, and the risk of res judicata and multiplicity of proceedings. Now, it is my humble submission that the current proceedings should be allowed to deviate on issues that are not relevant, or rather we should focus on whether or not the claimant or the parties have breached the terms of the MOU, the STA, whether the defendant shareholders resolution in cooperating with the operations of the claimant. So this is where I think the whole issue and the discussion should be, rather than focusing our attention on investigations which are not relevant and material to the current compensation claim.
Your Honor, if we get a positive order in CFI 019, which is a petition for derivative claim, then the claimant's claim in this case will have no value, because that would establish the number of unlawful activities done by them, which we have presented separately in that case. And also, Your Honor, just to highlight the point that while it's prima facie, the court has already agreed with our issues. And the court is satisfied so far that they committed the breaches before issuing the earlier order.
Are already discussed in that case.
Yes, Your Honor. So here, because they're asking for a compensation claim, points which describe that the money has been siphoned off are therefore important. So if you allow me, Your Honor, the $2.7 million, that's a dollar figure, right? So it would affect any amount claim that the claimant would be bringing forward. Second, where we highlight basically how the claimant has wrongfully used the good name of UAE governmental accreditation and how they got that by fudging the audit reports. If the audit reports are fudged, what goes in the audit reports again, books, records and accounts, right? That would affect the claimant's number. Point number 9, where we mention whether the claimants control a shell company called Patel Trading under the ownership of the domestic staff car driver, which is used to book secret profits by booking all cash transactions. This again affects the quantum because a good amount of money is being siphoned out of another shell company. So any claim number that they would be coming with, it has to factor in what money has been potentially embezzled from the company. So Your Honor, just to finally say, since the pleadings are same, what is the objection in adding our issues so that it's a fair trial and we can give a solid rebuttal to all of the points that the claimant will be raising in this case?
Your Honor, if I may please make my submissions. Your Honor, in the current case, the claimant is the company, and in the derivative claim, they are seeking these proceedings against defendant numbers 2 and 3, meaning the shareholders. Also, Your Honor, if you look at the list of issues that are proposed to be included in the current proceeding, if I may read out, whether the claimant has wrongfully, in contravention of all accounting principles, categorized loan as equity for the purpose of showing net worth in excess of 16 million to meet the regulatory requirement of UAE good delivery and accreditation laid by Emirates Bullion Market Committee. This is definitely not an issue to be investigated in a compensation claim. Also, Your Honor, the second issue, whether the claimant has wrongfully used the good name of UAE government accreditation such as UGD, Emirates Bullion Committee, DGCX, etc., as defined in Part 5 of the claim, and sanctioned countries such as Russia, Zimbabwe, Eritrea, Mali. Now, in a compensation claim, are we to investigate into these violations? If these violations are the defendant's case, then why is the defendant not making any counterclaim? He doesn't have a counterclaim.
To make a counterclaim,
we have to spend the time looking into and investigating into issues that are not relevant to the current proceeding. Also, Your Honor, the point number 4, whether the claimant control a shell company called Patel Trading Free Zone under the ownership of the domestic car driver, 100% of the shareholder. There is no, the defendant does not have a case that because the claimant entered into transactions with Patel Trading, I suffered a loss and X amount is my loss. Please compensate me. They don't have a case. They also don't have a case that because you have violated the UAE government accreditation, I suffered a loss, pay me the money. They don't have a case. Again, point number 2, the defendant does not have a case that I as a claimant violated the accounting principles. Because of that, I suffered a loss. They have no requirement. I mean, they have no counterclaim. They have no money loss. All they have to do in the current proceeding is defend the claimant's compensation claim of 15 million. Now, the point is very, very simple. What is our case? We are saying we have agreed into certain agreements with you, which you have breached. Now, the defendant, what they have to do is they just have to establish whether or not they have breached. If not, why they think that they have not breached. Now, it's a very simple case, Your Honor. We don't have to look into all of these complications because the more we get into all these breaches and violations, we will be deviating from the main case. We will not be coming to a conclusion on whether or not the claimants are entitled to the compensation. Rather, we will be coming up to some findings which does not really help the claimant's case. Now, parties are at liberty to bring any number of cases. Now, if the defendant had a case that they have suffered a loss, why did they not bring in a Part 7 claim? All they have made is a Part 8 claim. The first one, an injunction application. The prayers are the same. They want the accounting records. They want the audited financials. They don't have a compensation claim in the Part 8. The second claim, derivative claim. Again, they are throwing in the same list of allegations. And what do they want? They want accounting records. They want access to books and records. Now, in the compensation claim also, they are throwing in the same set of allegations and they want an investigation to be done in this. Your Honor, the strategy is very clear. The strategy is just that they want to do a free run on our accounting records and books, and they want to get hold of these documents by framing issues which would help them achieve their objective. And Your Honor, it is my humble submission that we should not let that happen because that would sabotage the claimant's case. We have a very simple case from the claimant. The claimant is saying, defendant being a 25% shareholder, they had certain obligations to do, which they have failed to. And because of that, it affected my operations and I have suffered a loss. Now, the obligation, the burden is on me to prove the loss, not on him to, if he doesn't have a claim, to prove the breaches. The breaches, irrespective of the outcome in the breach, my compensation claim will still prevail. If I am unsuccessful in proving my loss, my case would lose. I would suffer, that's all. But at my cost, the defendant should not be led to investigate and be given access to my books and records. And that is the only intention in which the strategy in which they would want as a specific issue to be framed so that they can raise disclosure requests, document access to compromise our case.
Your Honor, the breaches will prove that their case is frivolous. And just to highlight, in CFI 019, the derivative case, we have filed that we will bring forward a claim after we know the amount. And as Ms. Asha just said that that the defendants, which is us, aims to have a free run at the books and records of the company. We are 25% shareholders. As 25% shareholders, you have a right to access books, records, and annual financial statements, which the defendants in this case have not seen for last 2 years. And whatever we have uncovered so far shows that the books are being cooked, and that argument and the evidence we proved convinced the court in CFI 006, and we're happy to share that order with your lordship. And also in CFI 019, we are waiting for the ruling to be passed, which will allow us access, and that is what indeed would prove that the case is frivolous. Finally, just to highlight, since their Part 7 claim is a money claim indeed, the $2.7 million of fake dividend vouchers touches to the value that they are setting, number one. Second, when they're referring to the Patel Trading Company, we have evidence where 33.8 million dirham, which is approximately $9 million, is the cash collected by in this site in that company for for booking secret profits. That addresses any quantum that they said. So the points that we're highlighting, Your Honor, are evidences which bring numbers to which brings number forward, which can then be added or subtracted to the quantum that they have set of $15 million. Of course, given the limitation that we've not had access to the audited statement, and that is what the claimant, the company, should be sharing with us. And finally, Your Honor, sorry.
Yeah, continue.
And finally, Your Honor, all the defendants are party to the other claim, which is the company. Sam Precious Metal, Ms. Asha said that it's only defendant 2 and defendant 3 which are in the other case. That is not the case. That is not the situation. Sam Precious Metal itself is party in both the injunction order case and the derivative claim. So just to summarize, without having access to the books and records of a company where we are entitled to, as being a 25% shareholders, and by demonstrating that unlawfully, payments are made out, that addresses to any quantum that the claimant wants to set, and that's why we believe, these should be added, Your Honor.
This is when you file a counterclaim, you claim those stuff.
But yes, Your Honor, to get the counterclaim, we have filed for the derivative claim, for derivative action claim.
Okay, so to me, I'm satisfied with issues which start with whether the defendants have breached the agreed terms and conditions going forward to liability of the first, second, and third defendants to compensate the claimant for the loss in 1, 2, 3, and 4. I believe 1, 2, 3, and 4 are the issues 1, 2, 3, 4 of the same list of issues. And then I'm satisfied to add whether the claimants have wrongfully issued a forced dividend voucher to the defendants for an amount of 2.7. And that's it. The rest of the issues I'm not satisfied to add them to be discussed, as the claim before us is only compensation for the claimant, and the defendant have not filed the counterclaim to seek those issues.
Your Honor, if I could.
So,
Your Honor.
Yeah, yes, please.
Your Honor, the issue of Patel Trading, where in the month of March 2021, we have evidence that defendant number 2 and defendant number 3 have taken out 33.8 million dirham, approximately $9 million. That sets a dollar figure to the transactions that we have the evidence for, and that would that would help us in bringing this to this case.
How?
So, Your Honor, if the claimant sets a value of $15 million, and then and against that, if there is an evidence that $9 million has been already taken out by defendant number 2 and defendant 3 in cash transactions using a side company, that should reduce the claim from 15 to 9 million.
As I mentioned, this claim is for compensation and damages. Okay, this claim is for compensation and damages. It's not in relation of those amounts. If you're claiming those amounts as you're entitled to, then you have to file a counterclaim claiming that this company have taken out already $9 million, or the figure you're mentioning. Yeah, but you're not claiming that.
Yeah, yes.
And the figure provided by the claimant should be supported by evidence that they suffered this loss. And how did the defendants, what's the defendant's effect for the claimant to suffer this loss? You agree with me?
Yes, Your Honor. I see, but if the claimants change the pleadings, we need an opportunity to file a counterclaim. And we have registered in the other case that which is CFI 019, that we aim to file counterclaim, but only after we have access to books and records, which as Your Honor can see, that we have not had any access to that information.
And you claimed this access in CFI 6 or CFI 019?
CFI 019. If the petition is accepted, Your Honor, we should have that. And of course, I think also in this case, as it proceeds, we would file that request, access to documents in disclosure.
Okay. From the meantime, let's not add this list of issues until you file your counterclaim. Then you can request for those issues to be added, because you'll claim this amount, yeah?
Yes, Your Honor.
Yeah. But in the meantime, let's leave it as it is. I'll just add the 2.7 part of the list of issues, and the rest, which are, as I mentioned, whether the defendant, which starts from point 1, whether the defendants have breached the agreed terms and conditions, up to point 6, which reads liability of first, second, and third defendant to compensate the claimant for loss in 1, 2, 3, 4. Yeah.
Much
So those will be the issues of this claim.
Okay. Thank you, Your Honor.
And then moving to the case management draft order.
Your Honor, the timelines will slightly vary as we are planning to bring in some modifications to the statement of case, amendments to the pleadings.
You should file an application for that, yeah?
Yes, we will be making an application for amending the pleadings, Your Honor, and we would also estimate that there will be 4 weeks delay in the procedural timetable because of this new amendment application that will be introduced.
But on the current CMC order, have you agreed on this?
Yes, Your Honor. We have agreed on the dates, but we have not discussed about the amendments to the pleadings. This was decided at the very last stage. So the CMC order dates may also undergo changes subject to the application for the amendment.
So, Your Honor, new pleadings can give rise to new issues. That's our point.
So for the purposes of the current today's hearing, Your Honor, can we agree on these dates and then principally agree that if there is an application for amendment, then the timelines will further extend by 4 weeks or 6 weeks, just to accommodate and make it easier for the procedural efficiency. I think Your Honor is available online. The video seems to be frozen. Is that the same for you also, Mr. Chauhan?
Yes, I believe.
Just 1 second, please. I'll check with the judge right now.
Sure, thank you.
We are in agreement with 4 weeks extension. That's okay with us.
Thank you.
Can you hear me?
Yes, Your Honor, we can.
Okay, I'm very sorry. I think there is an issue with that connection. Anyways, in terms of the current CMC order, you can hear me, yeah?
Yes, Your Honor. So we have agreed, Mr. Chauhan has also agreed with us for a 4 weeks extension for the amendment to the pleadings.
Mm-hmm.
So on that basis, if we can work out the remaining procedural timetable,
Yeah.
we will internally discuss and come back to Your Honor with the fresh dates based on this anticipated application.
Mm-hmm.
And accordingly, we can finalize the CMC order.
Okay, so there are no issues between the parties, yeah?
No difference of opinion. Parties are agreeable to the extension of time.
Yes, we are in agreement.
Okay, send the courts the updated CMC order. Yeah.
Your Honor, also, now that Mr. Chauhan has also agreed for the amendments to the pleadings, should we make a separate application or can we take it as that has been agreed by the parties and accordingly modify the pleadings?
If it's agreed between the parties, then you don't have to file an application.
Yeah, we are also happy to give an opportunity for the defendants to make a reply based on the modified pleadings. So if a separate hearing can be avoided and if we can agree on that, I think that would be really, really helpful and grateful.
If the parties agree on that, then I don't have any issues. But list the dates, the deadlines, and the CMC order.
Yes, Your Honor, we will.
Of the amendment and of the reply. The defendant's reply to those amendments.
Yeah, we are looking for a 2 weeks time to file the modified pleadings. And
2 weeks is a lot to file a modified CMC order.
No, Your Honor, the modified pleadings.
Modified pleadings, okay. But list them in the CMC order, which you'll file by Monday or Tuesday, I assume.
Yes, Your Honor.
Yeah?
Yeah. And accordingly, we are happy to extend 2 weeks time for Mr. Chauhan to file his response to the modified pleadings. So altogether, we are looking at 4 weeks.
Okay.
Agreed, yes.
Anything else from the parties?
That's all, Your Honor.
I'll expect modified. I'll expect the CMC order to be sent to the courts for review and approval by Tuesday.
Yes, Your Honor.
Yeah.
Yeah.
Thank you.
Yes, Your Honor.
Thank you very much.
Anything else from the parties?
No, Your Honor. That's about from the claimant side.
That's all for defendant, Your Honor. That's all for us. Thank you.
Thank you, both parties.